judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Matter of Hull Hazard versus Roberts.
Ready at the court, please.
Marker.
I ask the court's permission to reserve 5 minutes of my time, primarily to argue my position as respondent with respect to the cross appeal, if necessary.
Fine, if necessary, sir.
Thank you. Your Honors, the Commissioner of Labor, we contend, was justified under the unique and particular circumstances of this case to hold the Hull Corporation equally responsible for the violations of the prevailing wage law by Hull Hazard. The Appellate Division's decision to the contrary should be reversed for 3 primary reasons. First of all, the court wrongly focused on the change in ownership of the corporation to the exclusion of all other factors, which demonstrated that the Hull Corporation was essentially operating the same business as the Hull Hazard Corporation's highway construction business.
But
Marker. Sorry.
Hull Hazard continued in existence as well, did it not?
Hull Hazard ceased bidding on public work projects at the end of 1983, and as to whether it exists in some form or is defunct, the record doesn't indicate, but the record is clear that Hull Hazard did not bid on any public work contractors after the end of 1983, and there was no anticipation that Hull Hazard would again begin to do that.
But it could hardly be a successor to a corporation if the corporation itself continued in existence.
Well, the corporation, the highway construction business of Hull Hazard, with respect to public work contracts, did not continue in business. That is clear from the record. That work was taken over or continued by the Hull Corporation. That, I would submit, is supported by the record.
What you really have, as I understand it, is 2 separate corporations with some of the same directors, officers, and employees.
I would submit that it is much more than that, and I would refer to Justice Levine's decision, which enumerates the many factors which show that the Hull Corporation was the same business as Hull Hazard Incorporated. Those factors include that 1/2 of the voting shares of Hull Corporation were owned by the principal shareholders of Hull Hazard. 2, that the remaining half of those shares were held by the president of Hull Hazard. That the Hull Corporation had the same officers and directors as Hull Hazard. That the majority of the top managers in the Hull Corporation were the same as those top managers in Hull Hazard. 5, that the same office and administrative staff was used by the Hull Corporation to begin to perform public work projects and to bid on public work projects. That both corporations had joint pension and welfare benefit plans. That Hull held itself out by Stephen Infanti, the president of both Hull and Hull Hazard during 1984, as the continuation of Hull Hazard's business in documents that were submitted to the Department of Labor and which were sent to businesses with which Hull Hazard had a business relationship.
Well, Infanti had no interest in Hull Hazard, though, as far as ownership interest is concerned, did he?
That's correct. He did not have an ownership interest in Hull Hazard, but focusing on ownership alone, I think, would be wrong, because stock ownership, as this court has recognized in myriad of cases that involve holding one corporation liable for another corporation's violation of law or torts or contract violations, is easily manipulated and does not really reflect the realities of the business.
Is this a manipulation case, or is this a case where you say the authority for the Labor Commissioner to do what she did is plain?
This isn't a case, Your Honor, where we contend that Hull Corporation was set up to avoid the commissioner's order against Hull Hazard.
So then your argument necessarily has a much broader reach in terms of the implications for putting certain businesses as successors on the foreclosed list, doesn't it?
Well, we don't take the position that every successor corporation can be held liable for its predecessor's violations. We are not reaching that broadly at all. What we are saying is that where the business is the same, where the successor continues the business of the predecessor with substantially the same officers and directors, holds itself out as being the successor, the continuation of that predecessor's business, it is reasonable and it is necessary in order to effectuate the purposes of the prevailing wage law to hold that successor liable for the predecessor's violation.
And what is the source of the authority for the commissioner to do that under those circumstances, assuming we were to agree with that part of your argument?
The source of the authority is this court's recognition that an administrative agency has not only that authority that is specifically laid out in the statute, but that authority that is implied in order to effectuate the purposes of that statute that the officer is charged with enforcing. So the labor law itself, in Section 21, gives the Commissioner of Labor broad authority to issue orders as are necessary to effectuate compliance with the purposes of the labor law. The Commissioner's evaluation in this case, which was based on her knowledge at the time that the notice of hearing was sent, that Hull Hazard was no longer performing highway construction work for public work projects, and that Hull Corporation had continued that business with essentially the same officers and directors, the same shareholders, the same workforce.
Any of the same contracts or different contracts?
Well, they could not have the same contracts, Your Honor, because there is a prohibition against assigning public work contracts to another contractor. So what the situation was, and I think, you can imagine it, is that Hull Hazard was phasing out of the highway construction public work business. They continued to perform the contracts that they had undertaken to perform, and at the same time, Mr. Infante and the Hulls were gearing up with the Hull Corporation to continue that portion of the business. The other individual, Mr. Hazard, had split off and started his own business along his own interests, which was real estate and commercial business development.
Ms. Parker, is this generally a matter of factual determination? I mean, what is the underlying principles of law here? When we look at this, are we to say, well, they were so interlocking that the answer is yes, or they were not so interlocking, therefore the answer is no, and that each case is sui generis?
Your Honor, I would agree. I would have to state that it is a heavily factual inquiry, and each case will depend on the nature of the facts as to whether one corporation will be held liable for another corporation's violations of law. That's how the law exists in corporate law in general. And in the labor law area, there are many analogs which can be looked at and which the commissioner looked at in order to find that this corporation should be held liable for Hull Hazard's violation. But the essence of it is the second business under the same control and direction as the first business? And the talisman has to be what is necessary to effectuate the purposes of the statute. In this case, the prevailing wage law has a number of purposes: to ensure that workers are paid the prevailing wage, and to do so by having certain deterrents in the law. One of those deterrents is that the commissioner has the authority to find a willful violation. If the commissioner is precluded from holding the responsible parties to have willfully violated the statute, that deterrent value will be essentially undercut, because the commissioner will not be able to look at whether this corporation has evolved into some other business, albeit on under a different name, in order to determine whether that corporation is responsible for the violations.
Do you draw any distinction between the civil penalties that might be assumed and the debarment penalty?
I don't think there is any distinction between the civil penalty and the willful violation penalty, although the civil penalty, there's only joint, I would say there's joint and several liability for the civil penalty, because if the civil penalty is paid by the predecessor, obviously the successor is not going to be required to pay that penalty. But if
there is a finding of violation, the debarment is automatic?
not after this court's decision in Dadson Plumbing v. Golden, I would say that there has to be in each instance an evaluation of whether there was a knowing repetition of the willful violation. The debarment provision itself doesn't preclude the commissioner from finding more than one person or more than one corporation responsible for a willful violation. What the debarment provision does, if it's strictly construed, is limit the commissioner's authority to hold a corporation that was not found in two willful violations to have violated the statute. For example, in this case, if Hull had not been a party to the proceeding, had not litigated all of the issues that are part of this case, had not been on notice that it was being charged with a willful violation, you would have a different situation. That is not the case here. The commissioner is not trying to hold Hull responsible for a willful violation to which it was never a party to the administrative proceeding in which that violation was litigated. That's what makes this case different from the debarment of one corporation for another corporation's violation.
Ms. Barker, I believe earlier in response to one of the Chief Judge's questions, you discounted ownership in your calculus, and I notice you emphasize direction and control rather than ownership. Why wouldn't ownership be, since those who direct and control the corporation are ultimately responsible to the owners of the corporation, why isn't ownership the more significant factor?
I wouldn't say that ownership should not be considered. Ownership is certainly a factor that should be looked at in every case. But because stock ownership can be manipulated, changes hands frequently in publicly held corporations and privately held corporations as well, it shouldn't be focused on as the sole determinant of when a successor should be held liable for its predecessor's violations. It should be a factor, of course, and in this case, what is striking is that the new owner was the president of the former corporation. So it's not as if there's an innocent investor who is being held accountable for someone else's violations. This is a situation where the new shareholder, the new stockholder, was actively involved in operating and directing, and as the record shows, had knowledge of the violation in this case that were committed by the former corporation. So you have to look at stock ownership. It would certainly be a factor to be considered, but it shouldn't be the sole factor, because to do so, you would be permitting stock ownership to be manipulated, to be used in order to evade the purposes of the prevailing wage law. Thank you.
Thank you very much, Ms. Barker. Mr. Oliver?
Thank you, Your Honor. Your Honor, I'd like to address briefly the issue of joint liability, and I'd like to begin by distinguishing the debarment provisions of Section 220B from those contained in other state statutes that are cited in opposing briefs. Finance Law, Section 139, Public Authorities Law 2876, and General Municipal Law 103B all deal with the situation of an officer or a director of a corporation who is called before a grand jury to testify concerning a public contract, and who either refuses to sign a waiver of immunity or who refuses to provide testimony. In that circumstance, debarment of the corporation with which the officer or director is involved takes place for a 5-year period. In such cases, the debarment is automatic and is triggered by the investigating officer's ministerial task of simply notifying the appropriate state agencies that the refusal has in fact occurred. The debarment remains effective unless and until the corporation commences a special proceeding before the court to remove the disqualification. The factors considered in whether or not that disqualification will be removed are the amount and degree of control and financial interest of the director or officer in the corporation, and whether the public's interest is served by the corporation's continued disqualification. Now, in contradistinction to that situation, under Section 220B, the Commissioner makes no determination of willfulness until after a full investigation has taken place, until after the conduct of a hearing at which testimony is taken, evidence is presented, and all defenses and circumstances have been considered. Thus, unlike the other situations, the Commissioner's imposition of joint liability in this case upon Hull occurred only after the Commissioner had investigated and determined that assessing joint liability was in fact in the public's interest and would serve to effectuate the purposes of Section 220. Additionally, as was mentioned earlier, no debarment could occur despite the finding of a willful violation or the imposition of joint liability until two separate final determinations of willfully violating the statute had occurred. I would submit based on this that Section 220B's debarment provisions are wholly different than the others that were cited. I'd also like to make clear what I'm not advocating here. I'm not advocating the automatic imposition of joint liability in every case where there is a sale or a transfer of ownership. I'm also not advocating the wooden application of any per se rule.
Mr. Oliver, excuse me, before you tell me what you are advocating, why are you advocating it? You're here as on behalf of the operating engineers, as I understand. Is that correct?
That's correct, Your Honor.
And how directly does this affect you in this context, this case?
This case has a direct effect on the ability of, in the case of the clients I represent, union contractors who are bound by the provisions of the prevailing wage law to remain competitive in bidding on public works projects.
Now, if this case came out the opposite from the way you would advocate, they would not be paid the prevailing wage rate as successful bidder?
Employees on the project are required to be paid the prevailing wage rate.
That's what I would think.
Yes.
So when you, for example, in your point one, you say tying of rods and labor work was required to be paid at the iron worker's rate.
Yes.
Does anyone quarrel with that? And if so, in what respect?
Well,
And forgive my ignorance in this, I'm just...
all right, the quarrel with that is on the cross appeal, which claims that the Commissioner's determination that tying of rods and bars should be done at the iron worker's rate rather than the laborer's rate was incorrect. The issue of joint liability, however, the concern there is that one of the reasons that 220B was enacted was because prior remedies under the statute had been found to be ineffective to provide a deterrent, because a contractor was free to submit a lower bid, commit a violation of the labor law, and then if he was caught, to simply pay whatever was owed plus a small fine. There was really no disincentive against continuing violations of the law. In this case, one of the results that could obtain if the Commissioner was in no circumstance allowed, irrespective of the record, irrespective of any showing, to impose joint liability, in this case upon the only remaining viable business entity, that being Hull, it would counteract the deterrent purposes of Section 220B.
Just to follow up the Chief Judge's question, because I have the same concern, your interest is with the future rather than with this case in particular. Is that so?
Well, I'm concerned with this case, certainly with respect to the ironworkers pay and the cross appeal, but whether or not there is a determination of joint liability here will not affect the appellate division's order that, in fact, employees who should have been paid at the ironworkers' rate were paid at the laborers' rate. There's no question that the alleged payment out of classification is not directly tied to this, except insofar as in the situation where one corporation, for instance, becomes defunct and is therefore, based on any withholdings that have previously occurred, unable to satisfy the payments that would be due. If no liability could be transferred to any successor or to any continuing business enterprise, then in that case there could be an effect on whether or not payment was in fact obtained.
Do I take it then, and correct me if I'm wrong, that you are arguing neither for nor against the debarment sanction that's involved?
Oh, I am plainly arguing in favor of it. Plainly arguing in
Because of
favor
the
it.
therapeutic effect it would have in deterring this kind of misconduct.
Not only the therapeutic effect, but because I think it is necessary to effectuate the purposes of the statute. I think that despite the fact that the debarment provisions can be harsh, that 220B has to be viewed in conjunction with the overall statutory scheme of Section 220, which is clearly remedial and which is designed to protect workers on public projects.
Can you conceive of any situations where the overall statute might be applied to a successor, arguably a successor corporation in the sense you're using it, and the debarment proceedings would not be?
Yes. In this case, if the successor to the highway portion of the business had been Robert Hazard, who had not previously been involved, who was not the one who directed the project at issue here, in this particular case, Mr. Hull, who is the 50% owner of Hull Corporation, was the project manager of the project. And Hull Hazard was essentially two corporations, with the Hull portion always being directed toward the highway portion, and Mr. Hazard doing mostly the real estate. If for some reason, in the change of direction or the parting of the ways of the corporation, he had taken over the highway portion, and the policies of this new corporation were not necessarily the policies of the prior one, that he had not, in fact, formulated the policies on which the violation was found, I can envision imposing financial liabilities simply to ensure that the employees were paid, but not being able to establish that a willful violation occurred. And indeed, the statute specifically provides that the commissioner is fully able to find that a violation of the statute has occurred and that payment is due, but that such violation was not willful. The commissioner found that in this case, or the appellate division found that in this case with respect to an overtime violation. They reversed that portion of the commissioner's determination that found a willful violation on that count. The commissioner is free not to impose willful violations unless there's a proper showing, irrespective of the fact that a violation has occurred and money is due to employees.
But Mr. Oliver, you indicate that debarment, of course, is a harsh economic sanction. To impose it on a successor for the acts of a predecessor, should there not be a stronger root in the authority than the implied authority based on the generalized amorphous purposes of a statute?
I don't believe so, because I think that the implication of the commissioner's authority is absolutely necessary to effectuating the statute. And it obviously will have to be done on a case-by-case basis. It will be subject to review in each case, and the commissioner will be required to demonstrate that the imposition of joint liability was reasonable, that it's supported by substantial evidence in the record, and that effectuates the purposes of the act. It can't be woodenly applied, there's no question about that, but it's also impossible to draft legislation in such a way that every corporate form or twist of ownership would somehow be provided for. And I think the way the statute is worded, given the other provisions of the labor law, clearly looks toward the commissioner exercising discretion and authority to determine what liability will be imposed, and that is subject to reasonableness and to review, but that there is no requirement that there be some specific language, that it's implied in the language of the statute and in the commissioner's duties and obligations under the statute.
Recognizing the various permutations in ownership and the problem that creates in drafting, is it not, though, a legislative policy choice, and couldn't they do that and recognize that problem by simply at least expressly authorizing debarment in successor situations, leaving to the discretion based on a set of criteria that do not woodenly, lock up the commissioner's discretion? Wouldn't it be better to have it that way in terms of business people knowing what the potential and sort of Damocles really is out there in connection with something like that?
Well, I'm not sure that it would be better. They certainly could have done it. But I would argue that the fact that they did not do it does not preclude the commissioner from exercising authority under the proper circumstances upon the specific facts of the case. I would submit that this is such a case that the exact same people who controlled Hull Hazard on this project at the time the violations occurred are the people who are now controlling Hull Corporation. 99.5% of the voting stock in the Hull Corporation is owned by John Hull and Stephen Infante. The remaining 0.5% is owned by James Hull, who supervised the construction workers on this project where the violation occurred. I would submit that this is a case where it is reasonable, it is equitable, and it is absolutely necessary for purposes of the statute that joint liability be assessed. Thank you.
Thank you very much, Mr. Oliver. Mr. Odell, you got about 99% of the ownership here intertwined, didn't you?
No, sir.
No?
No. If I may be heard in that regard, and I think I can persuade you that these arguments do not hold that have been presented to this court. First, I think it important to note that the Hull Hazard contract that we're concerned with here, the road job, that contract was let in November of 1983. I think the next operative fact that's important here is that the Hull Corporation was formed in March of 1984. The Hull Corporation was formed prior to the complaint with which we're concerned in the Department of Labor hearing. It was formed prior to the hearing officer's findings. It was prior to the notice, rather, of a violation, and prior to the hearing that we're concerned with here. Hull Hazard, which was the corporation on the Public Works project, was owned by a corporation named Hazel, and it was also owned by John Hull and his son James Hull. Hazel, in turn, was owned by the Hazard family. Mr. Infante, whose name you've heard about in this argument, and a host of other people didn't own any part of Hull Hazard. In contrast, the Hull Corporation, which has been dragooned or pulled in to this hearing, and for which they seek to assign liability, is owned by John Hull, as has been mentioned, James Hull, as has been mentioned, but also the Hull Corporation is owned by Stephen Infante, a man named Carmody, a person named Dillon, an Amadon, a Holland, a Tuthill, an Urban, a Whalen, a Schultz, and a man named Morrow. 10 of the 12 people had no equity ownership in Hull Hazard.
What percent did they own?
I don't know as I stand before you, Your Honor. I have known, but I don't know. Mr. Infante, I know owns 20% of the stock. And I believe that the remaining portion is distributed among the other persons that I've named. Clearly, Mr. Hull owns, and his son, approximately 50% of the Hull Corporation.
Mr. Odell, you
Yes,
don't
ma'am.
dispute the proposition, do you, that there could be joint or successor liability?
In an appropriate case,
And what, to your thinking, would be an appropriate case, and from where would the authority derive?
Well, there is no statutory authority. In contrast, where the legislation seeks to have some form of liability, or when somebody is to be debarred for activity of this type, there's usually express legislative authority
But you acknowledge this could happen.
in an appropriate fact pattern. And I would say that an appropriate fact pattern is not before this court. For example, in this factual situation, there is absolutely no record evidence that the Hull Corporation is a successor in any context of that term to Hull Hazard's highway work, to Hull Hazard's plant or equipment. There's no evidence that they're a joint venture with regard to this matter. As a matter of fact, notwithstanding some of the things that have been said in the brief and in the arguments before this court, there's no evidence that Hull Hazard is out of business, that they've ceased work, or that the corporation is dissolved in the record before you. There's no evidence of a common enterprise of these two corporations. There's no evidence that the Hull Corporation continued Hull Hazard's business. The record evidence is that Mr. Hull was interested in highway work, Mr. Hazard was interested in building work, but there's no evidence of a successor relationship in that context. I think what the Department of Labor and the intervener have done here is, I think what they've done is borrowed from some inapplicable principles of federal labor law that have absolutely no application to these proceedings. For example, when we get over into the federal labor law area, and there's a labor agreement, and there's employees to be protected under that labor agreement, and that labor agreement is to be applied either to an existing corporation or a successor corporation, we do have a different body of law that is inapplicable here. There's no evidence in this record of a labor agreement. There's no evidence in this record of an unfair labor practice. There's no evidence in this record that would support, in the context of the federal labor law, a finding of an alter ego status as between these two corporations, or of a successor status in the context of the federal labor law.
But Mr. Odell, it sounds very much, having made a list of the criteria that Ms. Barker says would be material, you seem to be talking about the very same criteria, but just disputing that the evidence is there.
Non-existent in this record.
But you don't dispute her criteria of continuing the business and taking over the work and being a successor in a practical sense.
I would think that they would be appropriate but I think that if that were to be done, I think that there ought to be some legislative authority for it.
But you acknowledge that at the outset that there could be a joint or successor liability. And now in what instances do you feel it would be appropriate under existing law?
Where the legislature has expressly recognized that it should be observed, such as at the federal level, there's expressed federal legislation. I think that where there is a clear proof in the record of a successor relationship, which is not the case before the court in this instance, the court in its judgment might apply successor liability. I don't think we have
Let
that.
me just interrupt you there, Mr. Odell. Then the answer that you would give me would be the same answer that Ms. Barker gave me with respect to this being fundamentally, in many ways, I gather from your answers to Judge Kaye, a matter of factual determination.
I think there is, yes, but I think before we get to the factual determination, I think we have to first determine whether there is a policy to be served in reaching that end. And in looking for the policy to be served, I think perhaps one of the policies to be served is that one shouldn't run and hide from their obligations to their employees, and that you shouldn't be able to run and hide by the mere forming of another corporation that succeeds to the work, the plant, the equipment, the whole fabric of the preceding corporation, and then the preceding corporation ceases to exist, and theoretically the successor seeks to escape that liability. I think that's clearly a situation where the courts see a situation that begs for some form of appropriate remedy in that situation. That's not before the court. There's absolutely no evidence that Hull Hazard is financially unable to respond to the $262.66 penalty that is involved in this matter.
Mr. Odell, I must confess to a little bit of confusion. If we're talking about factual matters, then I don't understand the test you've asserted of clear evidence. It occurs to me, under some fundamental principles operating in this area of administrative law, that if there's substantial evidence, that ends it in terms of the judicial review, doesn't it?
The Hull Corporation, no, I don't believe so, Your Honor. And for these reasons, the Hull Corporation did not perform any work on this project. The Hull Corporation was not involved in the project in any way, shape, or manner. The Hull Corporation didn't come into being until after this contract came into being and prior to any of the events with which we're concerned here. And there is absolutely no evidence in the record of any form of successor relationship in the context of federal labor law or any other authority that they can cite in their briefs.
See, I understand the part about a source of authority, which
Yes,
I
sir.
inquired about earlier, and I can understand that at the threshold, creating some problems. But once we move off that into the factual evaluation of whether it looks like, sounds like, and moves like a duck, then I have other problems.
Yeah, and I'm suggesting to you that it doesn't look like a duck, it doesn't walk like a duck, and it doesn't quack like a duck, Your Honor,
Despite the hull.
despite them both being called duck. Yes, sir. If I may move to the subject matter of the cross
So
appeal.
long as you get out of the barnyard.
As you know, I'm trying to. If I may move to the subject matter of the cross appeal, I recognize at the outset that I face a somewhat awesome task of trying to convince you that there's no substantial evidence on the cross appeal. And I believe that I can marshal an argument to that effect. Hopefully, it'll be persuasive. The cross appeal relates to a finding of a willful violation of Hull Hazard having paid out of classification. And simplistically, what we're talking about is the unsworn complaint of a man named Albert Redmond, and which precipitated this entire matter. Ultimately, the commissioner made a finding that an employee named Kerwin had been improperly paid in the amount of $262.66. The underlying dispute relates to whether Kerwin or somebody should have been paid the laborer's rate versus the iron worker's rate, the laborer's rate being of a lesser amount. Now, in the ultimate determination, the original complainant, Mr. Redmond, received no back pay award. With regard to Mr. Kerwin, there's absolutely no explanation for the basis upon which he received the $262. Mr. Kerwin was the sole employee of hundreds of people that were employed on the project. Mr. Kerwin is the sole employee in the entire history of the Hull Hazard Corporation that ever received back pay by reason of a Department of Labor proceeding. It's undisputed that Hull Hazard had performed approximately $100 million of work of this nature. The pay classification dispute comes down to the matter of who ties wires on reinforcing bars in connection with bridge reconstruction projects. Hull Hazard historically had paid laborers for the occasional tying of those rebars. And the wires get busted apparently when from time to time with the utilization of these pneumatic hammers, which is trying to free concrete around the rebars that is ultimately going to receive an overlay of new concrete. They're busted and the man repairs the damage that he's done to the rebar that had been tied. Now, in the whole practice that they testified to on this proceeding, they had historically paid the labor rate for the occasional retying of these wires, and they paid iron workers' rate for tying rebars and like work when it was new construction, which was a situation where rebars are laid to a pattern in accordance with a diagram, and it has to be followed both with regard to elevation and the spatial relationship of the bars and the job. There were both types of work on this job, and when these men testified, neither of them differentiated between whether they were tying bars associated with the reconstruction portion of the project or the new work. Ultimately, in the hearing, 4 witnesses were produced by the intervenor, and they were produced after the Department of Labor had rested its case in chief, after we had produced some witnesses in contravention of their evidence. And the 4 new witnesses were Mr. Redmond, Mr. Kerwin, a man named Stagnita, and a man named McDermott. And Redmond had made his complaint to a probationary employee of the Department of Labor. That probationary employee, whose name was Burns, he never visited the job site. He didn't talk to any other employees. He didn't talk to the Department of Transportation representative on the job site, and he didn't look at any time cards. He relied on Redmond's unsworn statement. The business agent who testified on this proceeding, though they were local business agents, one a laborer and one an iron worker, could only, in one instance, rely on projects that were performed in Rochester, New York. Neither of them could identify a single contractor that had done any like work in the Syracuse, New York area, and neither of them could identify a single member of their respective unions that had been paid the rate which they claimed was applicable to this work.
Your time is up, Mr. Hogan.
I understand that, Your Honor. Thank you very much.
Thank you. Ms. Barker?
Just a couple points, Your Honor. With respect to the cross appeal, essentially the contractor's complaint is that they didn't like the investigation that was conducted by the Department of Labor, so they shouldn't have been required to go to a hearing, so there shouldn't have been an order of determination, so they shouldn't be here. But the fact of the matter is there was more than substantial evidence in the hearing record that the work that these 2 gentlemen were doing on a consistent basis since the first or second day of their employment was tying reinforcing rods, that work, that it was performed by iron workers in the locality of that project. Hull Hazard's own payroll records identified these workers, or at least Mr. Redmond, as an iron worker, and yet the company deliberately chose not to pay them the full iron workers' wages for all the work they performed. There's no question on the record that that was a willful violation, and the appellate division was correct in holding so. With respect to my adversary's arguments on the joint liability issue, I would just ask the court to put labels aside, whether this is a successor or some other sort of label attached to the Hull Corporation. The question really is whether the commissioner has the authority under the circumstances of this case to hold these 2 corporations which were basically acting as a single entity during the course of the violations were committed as equally liable for that violation. Thank you.
Thank you very much, Ms. Barker. Miller versus Schwartz.
Ready at 4, please.
Mr. Brezza, you claim there was a due process violation here?
Yes, Your Honor.
Could you step up to the...
Yes. May I make a request that I split my time to reply to the argument of the...
You want to reserve some rebuttal time?
Yes, sir.
Certainly.
Okay. May I proceed?
Please.
Your Honor, Your Honors, I'd like to briefly state the facts which give rise to the issues of law.
Now, we've read all the
before
briefs, as you know, and we understand the background and the facts of this case, and the fact that you believe that this conviction would...
There was no conviction.
That it would result, if there were a conviction, in the loss of a driver's license,
That
which
is
is a
true, and it's
substantial property right, and you feel that you would want some discovery in connection with this prosecution.
Right. The discovery being a subpoena ducis tecum so that I could obtain a copy of the operational manual of the radar that was used by the police officer who issued the summons.
Normally, you'd have to go through you'd have to complete your administrative
I
hearing.
don't hear.
Normally, you would have to complete your administrative hearing before you could challenge this
Well,
ruling.
Your Honor, it is true that the statute provides for an appeal from a conviction. And of course, we took an appeal based on the fact that we were denied the right to prepare for cross-examination. There was one factor that the courts and the law, the bar, seem to overlook. This Traffic Adjudication Bureau is a court for the common people who can't afford all of the legal procedures. And why should they have to...
That's why I'm holding you to the rule of administrative law, because it's an administrative tribunal, and normally administrative determinations can't be challenged until they're final.
Except that if the administrative tribunal denies bias procedures or bias statute a fair hearing, and a fair hearing means a meaningful right to cross-examination. Without the manual to prepare for cross-examination, I was involved in this case from the very beginning. And radar is a rather complicated device. A slight error in the operation of the manual procedures could result in a false reading. Isn't it fair for the defendant to have this manual to prepare for the cross-examination?
Well, you're claiming a constitutional right now. You're claiming a constitutional due process right.
Right.
There's no constitutional right to discovery in criminal prosecutions.
This is not a criminal prosecution. It's an administrative hearing.
Well, you're talking in terms of the defendant and fairness.
Well, let's call him the respondent. But this is an administrative hearing. An administrative hearing requires a fair hearing. And a fair hearing is a hearing which enables the respondent to prepare for cross-examination. And without the manual, I submit that it is impossible to have a meaningful cross-examination. Therefore, the violation of the rights begin ab initio, from the very time that we are made to appear before this the Traffic Violation Bureau without the right to prepare. Now, I'd like to point out, I was going to save this for my rebuttal, the position of the respondent here is that we have the right to cross-examination. She has that in her brief. A right to cross-examination is meaningless in this particular circumstances without having the manual. But let me also point out another thing. Not only has the Traffic Violation Bureau denied me a simple subpoena ducis tecum so I can obtain a copy, but they have provided themselves with a shield for me obtaining this manual from the manufacturer. I tried to get the manual from the manufacturer, and I received back a letter that under their agreement with the police department, they are not permitted, or they cannot supply me with the manual. I mean, this court, I'm sure, must recognize that radar devices are not perfect. Any mistakes in their operation would lead to an error in the reading. And weighing the equities of this case, why should a working person who gets a speeding ticket by way of radar be required to go through a hearing where his attorney tells him right from the beginning, I can't give you a fair hearing, I must have the manual? The TVB has prevented me from getting the manual. There's none available except through the police department. The police department, I wrote to the commissioner, says you can't have it. When you have the hearing, we'll show it to you.
Well, Mr. Bressler, you would be entitled to see the manual at the hearing, would you not?
But by that time, it's too late for meaningful cross-examination.
Well, how do you know that now?
Well, may I just point out my past background? I had formerly been an engineer. I was an electronic engineering officer in the Navy for 6 years during the war, and I submit that this court can take judicial notice that operations of radar equipment is not that simple. If I can't have time, if I asked to see the manual and said, can I take it home with me, can I make a copy and then adjourn the hearing until I prepare for cross-examination, the answer is no.
How do you know?
Well, you've got me there. I just assume...
That's why, now we can go back to Judge Simon's question. That's why these things are best gone through to their termination.
Well, my answer to this court is this, that one can always look at hindsight, and sometimes we could have done something that might have helped us. But the real issue before this court, in my opinion, is whether or not on a radar speeding offense, which is a third speeding, whether or not I am entitled to see this manual before the hearing proceeds, and especially where the TVB has taken affirmative action to prevent me from obtaining these required documents. It's not only denial of discovery, but it's concealing important documents that I need to prepare for a hearing.
Well, you don't suggest that this is directed only against you, do you? This is a matter of policy. This isn't simply directed against you and foreclosing your discovery.
Well, I believe that this is the reason why I am here, because I believe that I started with an Article 78, not with the declaratory judgment, because it was my opinion the statute is constitutional. The regulations are constitutional. It's the way the TVB is enforcing and proceeding on the rights.
As far as your client is concerned, in the context of this case, is that what you're saying?
Yes.
Then why didn't you raise an equal protection argument?
I don't see where the equal protection is involved here.
You might in about a month.
Procedural due process, in my opinion, involved in this case, and it's strictly a case of whether or not the appellate division, let me just get this last point, in the appellate division...
Well, you're on your rebuttal time now.
Okay, well, I have rebuttal time.
Well, if you keep going, you won't. Thank you very much. It's great. Why shouldn't the man be able to get the information he needs in order to conduct an adequate cross-examination?
Well, first of all, as a practical matter, as this court is well aware, there are numerous treatises and texts on radar. Radar is not as complicated as Mr. Breslauer makes it out to be, and that if he wanted to, he has numerous sources from which to get this information prior to the hearing, and there's no authority.
Doesn't he want to know about this particular piece of equipment that is used by the police department?
Yes, well, he knew what type of equipment was used, and as a matter of fact, there are many texts which talk about specifically this type of equipment. So when he came to the hearing, if he had, and I'm not directing this at him personally, if any attorney or even a pro se motorist read this information, he could come to the hearing properly prepared to cross-examine the police officer. And I think in addition, as a practical matter as well, that a police officer doesn't sit down prior to coming to these hearings and reread the manual. In fact, he probably knows what equipment he's using, how it's calibrated, when it was last calibrated, and how it works. And once he testifies to that, and that testimony is elicited, the state still has to sustain its burden of proving by clear and convincing evidence that the motorist was speeding. And unless we sustain that burden, the charge is dismissed. There is no constitutional right to pre-hearing discovery. In fact, in this case, the petitioner is afforded a full evidentiary hearing, and that includes notice of the charges, a hearing with the right to counsel, the right to testify and present evidence in a closing statement, the right to cross-examine adverse witnesses, the right to examine documents at the hearing, administrative review, and then Article 78 review. Due process calls for procedural protections as the particular situation demands. And in this situation, the petitioner was afforded all the protection that this situation demanded. Under the Matthews analysis, the petitioner in this case, private interest in the use and possession of his license is outweighed by the state's substantial interest in protecting the health, safety, and welfare of its citizens. One of the purposes of the mandatory revocation of a license after 3 speeding convictions within 18 months is to get the dangerous driver off the road as quickly as possible. And in this case, the petitioner, if convicted, I shouldn't say convicted, if the petitioner's license is revoked after a hearing, he has the right, because he claims that this license is used for his livelihood, to be issued a restricted use license for the period of the revocation. In addition, the suspension or revocation is temporary, and within 6 months he can make an application to get his license reinstated. And finally, the petitioner has not shown in any way that he could not use public transportation. So in other words, during the period of the revocation, the petitioner has not shown that his activities would be restricted in any fashion. On the other hand, as I suggested, the state has a substantial interest in getting bad drivers off the road. And in addition, there's the fiscal and administrative burden of providing discovery prior to a hearing. As I stated in my brief, I don't have more recent figures, but in 1967, shortly before this statute was passed, the Division of the Budget estimated that there were 858,000 moving violations in New York City alone. If the state had to provide, even if half of those went to hearing, and the state had to provide manuals or other discovery prior to a hearing, the administrative burden would be staggering.
Well, it wouldn't have to be free of charge, would it?
Well, it's not just a question of the cost, it's the burden of reproducing, but I think that the real issue is that there's no constitutional right to pre-hearing discovery, and in the context of this case, the petitioner received all the process he was due.
Thank you very much, Ms. Green. Mr. Breslauer?
Yes. May I first say that a particular text on radar, speed radar equipment, does not outline the procedure for each particular gun. Each manufacturer has their own procedure. Secondly, I dare submit that a pro se motorist, 99% would look at a radar book, and unless they were trained in electronics, wouldn't know what they're looking at. Secondly, as far as the police officer, naturally a police officer who's trained and uses radar equipment all day long, of course he's an expert on it. For that very reason, the defendant should have at least some opportunity to prepare himself for that particular unit. Now, it is true that the burden is upon the people to, not the TVB, to prove their case. by clear and convincing evidence. However, she also states, Ms. Green, that we're getting opportunity to cross-examine. That is the whole issue. There is no opportunity to cross-examine unless the respondent has the ability to prepare properly through the radar manual. Now, as far as the procedures of appeal and everything, I submit that the court should take into consideration that the average layman who comes into the Traffic Violation Bureau is not prepared to take appeals. He comes in and he pleads guilty, and that's what's been happening. Expediency has been replaced by TVB for due process. You can't say because of the amount of people and accidents that have taken place, therefore, anybody, let's have a Red Star chamber, we stamp him, he comes in with a ticket, he's guilty. He's entitled to due process before he's found guilty.
Thank you very much, Mr. Breslauer.
Thank you.
Bly versus Mapstoa.
Ready, report, please.
Mr. Krawitz, I've looked through this case. I'm still trying to find the hidden point of law here. I think that everyone would concede that Mapstoa certainly has some duty, but isn't this basically a conflict with respect to the facts?
Exactly, Your Honor. May it please the Court, before I commence, I would also like to reserve some time to rebut the arguments of Mapstoa.
All right, now, going to the facts of this case.
Your Honor, I believe that the appellate division, in expanding the duty, which they clearly did from Zuckerman to Bly, it's now settled, at least in the first department, that they have a